Here's the scenario I see constantly. You buy a rental property in your personal name because financing it turns out to be a much better deal. Then you form an LLC for asset protection. But here comes the critical mistake. You never actually transfer via deed the property into the LLC. You may do a lease with a tenant where the LLC is renting to the tenant and you think that's going to protect you, but if the property's in your name, that means you personally still own it. Let me show you exactly what happens in court when a tenant injury occurs and the property is in your name and maybe the tenant is leasing from the LLC. Legal experts consistently emphasize this point. You gotta transfer the assets into the LLC to provide yourself with limited liability protection. If you don't transfer the property into the LLC, you, the listed deeded owner, is the one who's gonna be on the hook. When a tenant slips on your icy walkway or falls through damaged flooring, they are going to immediately go find a plaintiff's attorney. And what plaintiff's attorneys know is they want to sue everyone they possibly can. So they're going to sue the LLC that's listed on the lease, but then they're going to go into the property records and they're going to sue the owner of the property. So the median award in personal liability cases, and think about this, is $90,000. And if the LLC doesn't hold any assets, it doesn't own the property, you own the property, they are going to come after you personally. They could get that property, and even more so, they could dip into your personal savings account or go after your primary residence. The liability here can explode in the event that you don't have the property properly titled in an LLC. So what's the solution? It's actually an easy one. Your LLC is only as strong as how you fund it, and most real estate investors are making this critical mistake, whether it's an oversight or they just don't understand, really becomes irrelevant. First, critically, you must transfer the property via deed from your name to the LLC's name properly through the county recorder's office. This isn't optional if you want that limited liability protection. Second, you have to update your insurance policies. I saw this firsthand with someone who transferred the property, but then didn't tell their insurer. And so the insurer, when the LLC did get sued, they said this isn't covered because it wasn't an additional insured on their policy. Call up your insurer and you're going to say, I want myself covered, but I also want the LLC covered by this policy. Third, you gotta keep the LLC funds separate from your personal funds. This means setting up a bank account for your LLC. Your tenants pay the bank account, pay into the bank account, and all of the transactions related to the property are paid out of that bank account. I know sometimes tenants want to pay you with Venmo or they're paying with cash or something else. Even in those scenarios, deposit the cash into the company bank account and get the Venmo account or the PayPal account or whatever processor you're using opened in the name of the LLC. Doing otherwise creates very significant potential for this LLC to be disregarded, the veil pierced, and your assets are going to be on the line. Finally, fourth, you're going to make sure every contract and lease you enter into related to that property list the LLC as the owner. This inconsistency, if you're signing leases in your personal name, if you're hiring contractors in your personal name, can create vulnerabilities that a plaintiff's attorney can exploit to your detriment. This is a warning. If there's a mortgage on the property and that mortgage contains a due on sale clause, which most do, you need to get the lender's approval before transferring the property into the LLC. Sometimes not a problem. Lenders don't care. You may at signing of the mortgage or closing on the property, ask the lender, can I transfer this into an LLC? They'll say, yeah, wait 2 months and then you can transfer it. In other cases, depending on the type of loan you have, if you got a VA loan, if you got an FHA loan, if you've got a commercial loan, if you've got maybe a hard money lender or seller financing, one of those things, you gotta get their permission, or it could be invalidated or potentially trigger the due on sale clause, and you're going to have some very expensive decisions to make about whether you do want to transfer that property ultimately into the LLC. Even the worst case scenario, the lender says, hey, we're triggering the due on sale clause. Come clean. I messed up. I didn't realize this was the case. Will you approve it now? They say no. You can unwind the transaction. Then there's additional steps you can take. And another point here, when you transfer that property into the LLC, it's a capital contribution. You're contributing, you're putting something into the LLC, and that should be documented with contribution meeting minutes or in your company operating agreement if the company's just been formed. So that creates the paper trail, shows that you are respecting the business entity, and therefore the courts should respect that business entity as well. You should consult with a real estate attorney or an LLC structuring attorney who specializes in these kinds of properties to get things right and do it correctly. Don't be the next investor who loses personal assets because they didn't follow simple paperwork related steps. Get that property in the LLC. Watch our next video. Really excited about this to learn about more common real estate investing mistakes.